Welcome, everyone. My name is Dan Kelly. I serve as Dean and Mengler Chair in Law here at the University of St. Thomas School of Law. It's my pleasure to welcome everyone to this great conference. Welcome in a special way all the faculty, staff, and students who have joined us. Everyone in the Minnesota community, legal community, including lawyers, judges, public officials, nonprofit leaders, and advocates for disability rights. I want to give a special thank you and shout out to my colleague, Professor Lisa Schiltz, who is a force of nature in helping to organize this event. She serves as the John Herrick Professor of Law here at the Law School and the Thomas J. Abood Research Scholar. In addition to all of her research and teaching, she teaches a special education clinic. It's one of our special clinics here at the law school. So thank you, Lisa. Let's give it up for Lisa for helping to organize this. The topic of today's event, disability rights on hold, how the fraud allegations and funding freezes are affecting the disability community, is extremely timely and important. Right now, both in Minnesota and elsewhere throughout the nation, disability rights are at the forefront of discussions, policy debates, and oftentimes those who are most affected are given the least platform and the least attention. But we should recognize that whether it's government funding, private philanthropy, all the charitable work that takes place, each dollar that does not go to a person who is disabled to help them live their lives of human flourishing and fulfillment, that's a dollar they're not receiving. And so the discussion and the topics and our panelists today will address a number of the key policy and legal issues that are emerging. I also think it's the perfect place and time to be discussing this because of the beautiful Schiltz Grand Atrium that we're in. And a special call out to the wonderful placards that are on both sides of the room. If you haven't had a chance to look at and read them, I highly encourage you to do so. They highlight a number of the historical both challenges going back to the eugenics movement and opportunities and advancements that have been made here in the state of Minnesota and beyond. The final reason I think it's the perfect place to be holding this conference is because the University of St. Thomas School of Law is laser focused and has been from its founding 25 years ago on human dignity. And in particular, the human dignity of each and every person made in the image and likeness of God. And that focus on human dignity and its relationship to justice and the common good is not just something we pay lip service to in our mission statement and in our founding documents. It's something we try to live each and every year with our students. In fact, Professor Schiltz and I both have the privilege of teaching our Moral Reasoning for Lawyers course, which is the first course that all law students take here. And the first case of that first course is Buck versus Bell, an infamous Supreme Court opinion written by Justice Oliver Wendell Holmes that, and this is one of the reasons we use it with our students, completely ignores the human dignity of each and every person, and in particular, those that the court characterizes as disabled. They use much harsher language, but it's an opinion, and there's infamous lines in that opinion that we want our students to be aware of as they think about issues of law, justice, and morality. So with that backdrop and background, I welcome all of our panelists. I welcome all of you. Thank you so much for coming, and enjoy the discussion in this afternoon. Thanks so much.
Well, good afternoon, everyone. My name is Becky Thorson, and I'm honored to be part of this panel today and the discussion that we'll have today. And I'm thankful to Professor Schiltz, who has led this venture, and to the law school. I'm a relatively recently retired U.S. Magistrate judge, and I have been involved in some of the programming related to disability rights over the years. And one of the things I do want you to look at as you're hearing the speakers is these wonderful banners that you see, from beginning all the way around to closing. And the banners are entitled An Unfinished Journey, Civil Rights for People with Developmental Disabilities, and the Role of the Federal Courts. One of the themes in this exhibit is waiting for rights. Waiting. And this third panel has that title. And if you get up close to that panel, what we'll see is that people with disabilities waited 116 years for the right to treatment. They waited 117 years for the right to education, 123 years for the right to live in a neighborhood. They waited 132 years for basic civil rights. The Americans with Disabilities Act came 132 years after Minnesota became a state in 1858. 141 years for the right to the most integrated setting, 153 for the right to freedom from restraint and seclusion, and 154 years for the right to vote. And as that panel states, they are still waiting to be treated as equal citizens in life and in work. Today, you will hear about how the rights of people with disabilities are on hold due to the allegations of fraud. This is wrong. It's wrong. People with disabilities are not just victims of fraud, they are also victims of the response to fraud. What about their rights? As you engage in the program today, think about this. We've got the banner. We've got progress. We've come a long way. We still need to keep going. What will be our next banner? That blank slate. Think about what that next banner should say about how we handle this problem. What will it really say? I hope it says we resolved it, and I hope it says that we underscored the importance of civil rights for people with disabilities. Thank you so much for your engagement, and we look forward to the conversation today. I'll turn it over to Professor Schiltz.
Thank you, Judge Thorson. Judge Thorson was being really modest when she sort of suggested she dabbled in some disability things. She, along with Dr. Wick from the Minnesota Governor's Council on Disabilities, were the godmothers of this exhibit, which has now traveled to multiple federal courthouses and is now going to be educating students in all of the law schools in Minnesota. So thank you very much, Judge Thorson, and we'll see more of her in a minute. You all have the biographies of the speakers, and we don't want to waste time with things that you can read. So we're going to just move pretty quickly from person to person and panel to panel. And I am going to begin, and I'll just introduce who the next speakers are going to be, but then we'll move right into the content of the programs. So I'm going to start talking a little bit about, just so that we understand the whole problem here with the funding, how people with disabilities get the funding they need to actualize their civil rights, their important civil rights that they have won. And the banner tells us how hard they fought for some of these rights. But legally, people with disabilities have the right, the legal right to live independent, integrated lives in our communities. There's a lot of laws that are described in these banners that got them there, but the big kahuna is the ADA, right? The Americans with Disabilities Act. And most people, you think about it, you think about Title III, which is what gives us ramps and doors and openings. It's the physical accommodations. Also prohibits discrimination in employment. But our topic for today really focuses on Title II, which is it prohibits excluding qualified people with disabilities from participating in any of the services or programs that are offered by any public entity. It was that section, Title II, that was interpreted in this Supreme Court case in 1999, the Olmstead case, to mean that the ADA means that that is illegal discrimination for any state to keep people from disabilities in institutional settings if their needs can be met in community integrated state community-based programs. That's the right that we're talking about today, this constitutional right that was enshrined in this opinion by the Supreme Court. The Olmstead opinion was really important. Some call it the Brown versus Board of Education of disability rights, but it doesn't do anything except tell states that they cannot discriminate and that they have to let people live out in the community. It doesn't provide any places out in the community for any people with disabilities to live. Practically, a lot of people with disabilities need some support to get independent, to live independent, integrated lives. They often need support with the activities of daily living. That could range from bathing, dressing, feeding, doing household chores, handling money, transportation, shopping, living in a setting that is independent. Where do they get the money for this support? There could be a couple of places where you could get that funding. Job income, you could have a job. The unemployment rate for people with disabilities is about twice as high as for people without disabilities, and employed people with disabilities are almost twice as likely to be employed part-time as people without disabilities. So that's not often an option. Social Security, supplemental security income comes to, right now in 2026, $994 a month. It doesn't pay much rent or pay for very many services if you might need them. The truth is that the vast majority of people with cognitive disabilities live with and are supported by their families. And those families don't often receive or ask for any support for the work, the caregiving work that they do for their family members with disabilities. Now, this program is going to focus on the Medicaid system. So you need to understand that's only one of the ways in which people with disabilities might be getting the services that they need. But it's an important one, right? That's what we're going to be talking about. But I think that context is important, too, to understand that it's just a portion of people with disabilities who are even in the privileged position of getting and qualifying for the Medicaid services. Now, I'm going to give you just like the highest bird's eye view of what is an incredibly complicated system, just so that we have enough of a common understanding to be able to think about the fraud issues sensibly. And I'm not going to be able to focus on support for children or housing assistance, okay? It's going to really focus on support for the activities of daily living for the most part. Medicaid was created in 1965, and it was to provide health coverage for low-income people. It is a joint federal and state program. There are these federal laws that I've cited there, and there are a host of state laws that I've also cited there that govern the administration of Medicaid benefits. And the state and the the federal government have different roles. They play different roles in this. The federal entity that administers is the Center for Medicaid and Medicaid Services, CMS, within HHS. And federal law sets out basic mandatory eligibility categories, and it approves state plans that the states have to submit for how they're going to administer those programs, and monitors compliance with the requirements of federal law. The state agency here in Minnesota is the Department of Human Services. They call their Medicaid program medical assistance. DHS supervises the separate counties that administer the program. DHS determines eligibility for individuals with disabilities into any of the programs. They contract with managed care providers. They set reimbursement rates, all within the federal constraints and federal limits. They administer the waiver programs that we're going to be talking about in a minute, and they conduct appeals and hearings following the rules set forth by federal law. So the funding, right, the federal and the state government share the cost of funding these services. Every state has a different proportion of federal assistance in these services. There's a federal medical assistance percentage that's calculated every year, and it's keyed off of the per capita income of people in that state relative to the national average. In Minnesota, the share is about 50-50. It varies sometimes a little bit, but it's about 50-50. Now, remember, the federal government monitors and enforces its laws. Federal funding is conditioned on compliance with the federal laws. States can expand their programs. They can be more generous than the minimums that the federal law applies. But as long as it stays within, at least within the federal guidelines, then it's Minnesota that really has control of the Medicaid program for its Minnesota citizens. And if it doesn't follow the laws, then the federal government can withhold its share of the funding. Originally, these are the waiver programs. You'll hear a lot about them, right? Originally, the Medicaid, for way back from 1965, it could only be used to support people who were living in nursing facilities. But that was not really satisfactory, especially as people with disabilities started wanting to be more integrated in their communities. So in 1972, the Social Security Act was amended to provide for Medicaid to cover care in intermediate care facilities. And these intermediate care facilities were still institutional settings, but they're licensed, they have to follow certain health and safety standards, and they have to provide active treatment for people with disabilities. They can't just be living in the institution being physically cared for. Minnesota was very, very aggressive from the very beginning in funding and setting up intermediate care facilities. And then across the nation, by 1971, the expenses of those intermediate care facilities just were ballooning. And Medicaid, a disproportionate share of all Medicaid funding was being used for people in those settings. And part of the impetus then for 1981's expansion of where Medicaid could be used was financial. It was just too expensive to having these people live in intermediate care facilities or in nursing facilities. And so the waiver program was created, allowing states to create Medicaid programs to pay for supports and services in community-based settings. These were originally just for people who would qualify for institutional care. And there are some other waivers besides the home and community-based waiver, but we're just going to focus on that one for purposes of this talk. The waiver is the waiver of all the rules and regulations that apply to the nursing homes and the intermediate care facilities. Those are all waived by the programs that are set up by the state here. States, when they set up waiver programs, they can target specific populations. They can target specific types of disabilities. They can target specific areas of the state in which people will be offering those services. And they can cap enrollment and they do cap enrollment, right? CMS in Washington has to approve every waiver program, and the waivered services can't exceed the costs of institutional care, so they keep an eye on it, right? Subsequently past this, right, the waiver program was expanded to include some programs even for people who don't qualify for institutional care to get some level of support for their activities of daily living. Minnesota has established waiver programs really across the spectrum of all those possibilities that I laid out. But since states can and do cap the enrollment in those waiver programs, demand often exceeds availability. And people who cannot get off the waiting lists, if there are those for waivers, they may have to be staying in nursing facilities or intermediate care facilities. Nationwide, many waiver programs have long waiting lists. Really long waiting lists. People wait 3 or 4 years. And Minnesota historically has had waiting lists too. But since Minnesota adopted an Olmstead plan as part of the Jensen lawsuit, which was litigated by Mr. O'Meara and is described in some of these banners, right? Minnesota's been really aggressive in sort of changing the way it looks at waivers and offering waivers not necessarily based on program, but instead based on need. If you can get out of an institutional setting into another one, you have higher priority than someone who's already out in the community. So waiver programs, they get the same contribution from the federal government as all the other settings, all the other Medicaid services. But, you know, there's things to worry about, right, that we will be worrying about, right? The 2025 Reconciliation Act includes major cuts to Medicaid funding over the next couple of decades, estimated by the Congressional Budget Office to be around $911 billion. And those cuts, they're coming in the future. They are going to put pressure on states in offering these voluntary waiver-like and waiver programs. The budget bill also implemented some immediate cuts and some immediate restrictions that we've heard about that will affect people with disabilities, like adding work requirements, changes in cost sharing, reducing health care for immigrants, cuts to certain providers, and restrictions on provider taxes. So that's just a basic background so that you have a sense of how these services that we're going to be talking about are administered. Now we're going to have, we get to hear from Ms. Judy Randall, who is the Minnesota Legislative Auditor. She'll talk a little bit about her office, and then she'll tell us what she's seen about the scope of the fraud in these areas.
Good afternoon, and first I just want to say thank you to Professor Schiltz for organizing this, and thank you, sorry, I'm a hand waver, so I just already knocked something over. Thanks to all of you for coming. I'm going to start by just explaining a little bit about who I am, why I'm here. And I have to do this. Hold on, I'm going to get my bearings. There we go. Okay, and then I'm going to dive in a little bit just to talk about the fraud and the alleged fraud that has happened at the state level, and then also talk a little bit about the state's response to it. I think we all know we're in a pretty tough position here as a state, and I think, I'm gonna give away the punchline, but it's how can the state respond in an effective way to the fraud that has happened while also not hurting people who need services, right? So keeping those end people, the people in mind, but also keeping in mind the obligation, the very real obligation that state agencies have to all taxpayers. So that's kind of the context and the balance I'm going to be providing, and I apologize in advance if it gets a little wonky and technical, but I'm going to go pretty high level. So let me just first say kind of what the Office of the Legislative Auditor is and what the Legislative Auditor is. First of all, I am not the state auditor. I am not Julie Blaha. That's somebody who you vote for on a ballot every 4 years. So there's the state auditor in Minnesota, and then there's the legislative auditor. I'm the legislative auditor. You haven't voted for me. sorry. I'm appointed, the legislative auditor is appointed to a 6-year term by a bipartisan, bicameral legislative office. It's a very unique office that most people don't know about in the legislative branch. So the Office of the Legislative Auditor, and these are the key things that I always talk about. We're nonpartisan, truly nonpartisan, even though we're in the legislative branch. We are independent, truly independent, and we can talk a little bit about that if that's of interest, and then in the legislative branch. And so that means we serve the whole House, the whole Senate, all 201 legislators, every single committee. Yep, it's pretty hard, right? That's what you're thinking. It is. But the guiding light for our office is that we are about facts, information, data, truth, and really our only bias, if you will, is that we care about good government. We care about programs doing what they were intended to be doing. We care about state money being used how it's supposed to be used. And in essence, we're like the watchdog over public funds. Just real quickly, our mission and goals is to strengthen legislative oversight and hold state government accountable. We work for the legislature kind of most directly, but I also really think we work for the public. We work for the taxpayer. The reports and information we put out is available to everybody on our website. We are all about good management and program effectiveness and, of course, complying with the law. And ultimately, we produce reports that, our goal is that they're accurate, objective, timely, and useful. And let me tell you, we spend a lot of effort to make sure that they are accurate, objective, timely, we don't always do, useful. Just to give you a little sense of what we can look at anywhere state money goes. So we conduct audits, performance audits, program evaluations, special reviews, investigations. We kind of have this broad, a big toolbox of tools we can use to look at how state money is being used, and we can go anywhere it's being used. So we primarily focus on executive branch agencies, but we also have jurisdiction over the judicial branch, so courts, higher education, including the University of Minnesota, metropolitan government, so Met Council, the Airports Commission, all of that. And it even goes all the way down to grantees. Grantees, an individual grantee that receives state money, we have the ability to go down and make sure they're using state money effectively and as intended. Now, I will say that we have an office of 74 people total. And so you look at that jurisdiction across all of state government, all of we have to make choices and we can't look at everything we wish we could, but we do have the ability to. We also have the ability to look at all information of any kind, of any classification. So that gives us a real unique window into what is actually happening in a state agency, for example. We can go in, we can look at the underlying data that we need to look at to really understand how things are working, and then we can, summarize it up and provide a report that everybody can see with that not public information kind of underneath that we have access to, but of course we're not disclosing not public information to others. All public employees and those who receive state money are required by law to cooperate with us, and I would say that they generally do. If they don't, we do have the authority to issue subpoenas. Really try not to do that because I'm a big believer that at the end of the day, the state agencies and programs that we're looking at, we all have the same goal, which is to have these programs doing what they're supposed to be doing, providing the services we all think they should be providing, and making government as good as it can be. We also have a really strong ability to protect sources of information. So whistleblowers will often come to us and they are comfortable knowing that their identity can be protected. It's a really important source of information for us. It helps us know kind of where to ask questions, where to dig in, and maybe where to conduct an investigation. So that's just a little bit about who the heck is the legislative auditor and the Office of the Legislative Auditor and why I was even asked to come talk at all today. It's because we have been conducting audits, evaluations, and special reviews of state agencies for a little over 50 years. And so certainly, these are just a couple of the recent fraud in public programs that I'm sure you've heard about. And we have been doing work in these areas for years. And so a natural question would be like, well, why didn't you catch the fraud then? Why didn't you stop the fraud, right? I think that's a fair question that people often ask. And what I will say is that, excuse me, OLA, the Office of the Legislative Auditor, is responsible for identifying vulnerabilities and weaknesses in these programs and identifying recommendations and ways for the state agencies, for example, to improve, to strengthen their controls so that fraud doesn't happen. But we are not the people who ultimately do the work. We can only make these recommendations as the outsider and say, here are some opportunities for improvement. So here are some of the recent frauds. I know Professor Schiltz talked about, MA services is really the focus here, but I just wanted to acknowledge Feeding Our Future. You may have heard of it, was kind of a big fraud scandal, and frankly, they're still working their way through the courts, although they have dozens and dozens of convictions. And then, of course, there are lots of allegations in MA services and in child care assistance programs, and unfortunately, many other state-funded programs these days. So how does fraud happen, or why does fraud happen? And so I wanted to talk just briefly about something called the fraud triangle, which is pretty simple, but I think it helps to lay a groundwork that we can all talk from and understand from. So there's three sides to the triangle, right? So there's kind of three things that contribute to why somebody might commit fraud. So the first is motivation, right? Hey, I want money, I want a big house, I want a nicer car, I need to pay off my debt, whatever, personal motivation. The next is rationalization. Everybody's doing it. State would never notice if I take some money. I mean, I've seen some newspaper articles, honestly, that have said, well, it seemed like the state didn't even care. They were just giving away the money and not checking on things, right? These are all part of a rationalization. Then the final part of the triangle is opportunity. And that's where state government comes in, and that's where the Office of the Legislative Auditor comes in, which is state government should not be providing the opportunity for people to commit fraud. That is kind of, I would say, state agency responsibility 101, right? We're talking about some basic stuff. So how do you prevent the opportunity? How do you stop fraud? And I do want to be clear, the best defense is to stop it in the first place. Right now, Minnesota is in a situation of kind of, it's a pay and chase, and that is the worst place to be in. We are chasing down fraudsters. No, we want to be getting it at the front end. And these are the reports that OLA has been releasing for decades, saying, hey, here's an opportunity to improve. Here's a better place, here's a better way to handle this money. A metaphor that I use, that I scrapped from this slideshow, but here I am, I go off script all the time, is talking about a barn, okay, just a barn. And OLA does a lot of different work around the barn. Our financial auditors do something called performance audits, where they're going and looking at internal controls. This is like walking around the outside of the barn. We're checking the door, does the lock work? Is there a broken window? Oh, look, the roof is leaking. It's the maintenance, right? This is not rocket science. Right? This is the basic stuff we would all expect to do when we're taking care of our barn. This is, frankly, the basic stuff we would expect a regulatory government agency to do when they are giving out money to providers, to grantees, to whomever. Make sure they're providing the services, right? Crazy. Make sure that the reimbursement requests that they're submitting actually make sense and are related to the purpose of the program. Make sure they submit the required progress report. Does any of this sound hard to do? No, you're all going to shake your head no, because it's not. Does it all sound like a pretty reasonable thing to expect of our state agencies? Yes, it does. There are already laws that require all of this. There are already policies that require all of this. Hey, let's just do what we're already expected to do. These are the types of reports that OLA has been releasing over the past decades. Hey, you're not monitoring. You should monitor and make sure the services are being provided. Hey, you're not requiring the progress reports that are required so that we know folks are providing the services that we're paying for. You should look at those. You shouldn't pay until you get a progress report. You should check the financial reimbursement requests, right? Again, these are all, I would say, pretty basic things. These are called internal controls. That's the checking outside of the barn. Other parts of our office go in the barn and make sure the horse is like a racehorse, and we have I'm just going to tell you the metaphor real quick. Go in, there's a horse. Oh, you want a racehorse? It's not really a racehorse. Let's find better food, ventilation, blah, blah, blah. And then the other part of our office is the farmhand comes into the barn the next morning, doors open, horse is gone. Oh my gosh, what happened? Special reviews. Those are other parts of what we do. But in terms of what I think is relevant for today, it's, again, these basic things, these strong internal controls. Monitor, make sure the money's being used appropriately. Make sure your staff are trained so that they know what to do and how to check financial reimbursement requests and things like that. Another really basic thing that state government isn't great at, but we're getting better, always the optimist, you have to be, otherwise can't get up in the morning, is sharing information. State agencies notoriously, haven't been able to share information. So you might have somebody who's quote unquote a bad actor, a potential fraudster at DHS. Well, they can't say, hey, health, by the way, Judy Randall, bad actor there, don't engage with her, don't give her a grant. We didn't really have good information sharing before. And so guess what? If you're looking for opportunities, you can just kind of hopscotch your way across agencies. At least you used to be able to. And then program design. I work for the legislature, but I'm not above calling them out when they need to be. There are some programs that have been written into law in ways that do not give state agencies a lot of ability to hold them accountable. There's no licensure required, no regular checkups, there's no way to hook in and see if they're doing what should be doing. There's no way to give them consequences. So we need stronger laws to be written so that agencies can hold people accountable so they can go do it. Okay, am I doing okay? All right, I'm almost done. Okay, there has been some movement, I'd say, in addressing fraud, I'd say in about the last year, maybe 2 years. There were some executive orders that Governor Walz issued that kind of consolidated investigation efforts, so maybe we can pool the state's resources a little bit better. He appointed a director of program integrity who came out with a report earlier this week about ways to address fraud. I'd say in general, there's been a little bit more, emphasis on compliance rather than simply getting funds out the door. Legislature has also started to step up. They did pass a law this past session a year ago that allowed agencies to share some of that information, so that's good. They are aware of, or starting to become aware, I think, of their contribution to the problem and strengthening language and looking at that. And you may know that there's been a lot of discussion last session and this session about an inspector general. So how does this link into this whole panel other than just like a 101 on fraud and why it happens? I think that everybody, we all, but also the legislature and stakeholders are facing a real difficult challenge, frankly, on how to find the balance here. There is fraud, there has been fraud, and there's continuing to be fraud. And the state has to do something about it, has to get a handle on it. Period, right? We need to, I think trust in government is really low. I haven't seen recent polls, but every poll I see, it just seems lower and lower. We need to trust government. We need government to provide services, right? But we need them to actually use the money for those services and not give some of it away to people who are not using it as intended. And so how do we find the balance there, right? I think you all probably know, DHS swung pretty far one direction and said, okay, we're going to pause on payments, right? We're going to have this prepayment review for claims. And that put a lot of legitimate providers in a hard spot, caused a lot of people who rely on those services, put them in a really tough spot. So on the one hand, really bad decision for people who need those services. On the other hand, we got to get a handle on this fraud. And sometimes you have to just kind of start over or start fresh or I don't know that that's the right solution, and I'm not pretending I have the right solution, other than if I could roll back time and 10, 15 years ago, ask them to just please put in place some of the recommendations we made. But now that we're here, I do think there's going to be some tough decisions and balancing these needs that are all really, really important. but we're going to have to make some compromises along the way. It may result in some more bureaucracy and some more red tape, which I'm guessing a lot of people in this room wouldn't like. As an auditor, I love it, right? As an auditor, I'm like, yes. I mean, honestly, what I really want is like, just do the quote unquote red tape that's already required. Do it for all of them. You know, it shouldn't matter which program you're in or which agency you get your money from. They all have the same expectations and standards. Let's just do it consistently, and then we could provide the services that I think we all think are really important. So with that, I'm going to stop the ramble. Thank you again for your attention, and I hope you enjoy the rest of the afternoon. Thanks.
Thank you, Judy. Okay, now you get me again, and I'm just going to lay out some groundwork. I'm just going to be talking about the basic fraud allegations that affect us, people with disabilities, the most. The history, just basically lay out what has happened, and then I'm going to just lay out what have the federal and state responses been to these allegations. And then the following panelists are going to be talking about the consequences of the actions that have been taken. So the fraud allegations. First of all, the first major fraud case was Feeding Our Future. That started, the investigations all started in the FBI started in 2021, but there had been rumors of things before then, and some of the first prosecutions were brought in September 2022. It was the largest pandemic era fraud anywhere in the nation, and involved a program that was administered by the Department of Education. I'm sure there were people with disabilities affected by it, but it's not primarily dealing with the kinds of services that we were talking about in our focus. Our focus starts off with a program called the Housing Stabilization Services. On September 18, 2025, the U.S. Attorney's Office here in Minnesota announced 4 defendants in this first wave here. Additional defendants were charged. There were people who pleaded guilty in that one as recently as February 10th. Minnesota was the very first state in the country to be offering program, Medicaid coverage for these services. It was a program designed to help, among others, people with disabilities find housing, prompted by things that went on during the pandemic. The allegations that were being raised included misappropriation of funds intended for vulnerable people through fake and inflated claims, okay? That was one of the first big ones. Then the next big wave involved the Early Intensive Developmental and Behavioral Intervention Program, another Medicaid-funded program that provided autism services. Provided as a Medicaid benefit for kids and teens with autism that provides really intensive treatment options, including ABA therapy, which is intensive one-on-one behavioral therapy. And the allegations here included using unqualified service providers, aggressively recruiting parents to enroll their children and providing assessments, autism assessments for them that were shaky, and kickbacks to parents who enrolled children to receive such services. In December, 6 more defendants were charged and 1 pled guilty in 2025. The next big program involving services for people with disability is the Integrated Community Supports Program. And this was a waiver service designed to help people with disabilities live more independently in apartment-style housing rather than group homes. And I think it's one of the ones that Judy mentioned that it didn't need its own independent licensing, right? It was administered through the other waiver programs that we had. So, you know, maybe it could have slipped through some of the cracks. What's been announced in December was the unsealing of a search warrant for one of the big providers, and the press release said that this program was really vulnerable to fraud, just like the other 2, with the prosecutions, and allegations included billing Medicaid for services that it didn't actually supply. All of those cases were the results of investigations by the FBI, HHS, IRS, U.S. Postal Inspection Service, with help from the Attorney General of Minnesota as well, and the Bureau of Criminal Apprehension. This past January, the Minnesota Attorney General has announced that its Medicaid Fraud Control Unit announced a prosecution against an operator of a service provider for fraudulent billing in the same kind of arena of things. So these are the actions. These are the charges that were brought publicly. They got a lot of press, and they, except for feeding our future, they involved services for people with disabilities. So what were the responses to this so far? First of all, the federal responses. One of the responses was Operation Metro Surge, right? That was justified by the administration by being part of what the Trump administration is doing to crush Minnesota's fraud epidemic. And among the consequences of this, besides the tragic ones that we are all mourning, right, was the decimation of the Minnesota U.S. Attorney General office and basically the putting on hold all the fraud investigations by the federal government, by the U.S. Department of Justice that we just rehearsed. The other federal response was that CMS announced, Dr. Mehmet Oz, who's in charge of it, he sent a letter to Governor Walz providing notice of its intention to withhold $2 billion in Medicaid funding from Minnesota over the course of the next couple of years. And what they alleged was a substantial non-compliance with the requirements, the federal requirements of Medicaid, the Medicaid program. So back to my earlier discussion, this is what they have the authority to do, the federal government, if they think that the state is not following all of its rules. So the DHS has appealed this decision or announcement, and they're still waiting for a hearing to be set. So that's what's happened on the federal level. Now, what's happened on the state level? First of all, in July, so this is even before all these allegations were coming out, all these prosecutions happened, DHS sent a letter to CMS in Washington and said that it asked for authorization to terminate that housing stabilization program, saying that it had taken administrative action already to suspend payments because of credible allegations of fraud. And the governor ended that program in October 31st, 2025. So that's ended. Between September and September 4th and 23rd of this past year, DHS suspended payments to 11 providers in the ICS program based on credible allegations of fraud. So there were actions that were starting to be taken. Then in September, Governor Walz issued this executive order saying, we're serious about this fraud. These are a bunch of things that I want you to start doing. Directed the DHS Inspector General to identify programs that provided a high risk of fraud, and where appropriate, recommend changes, including termination of programs, and where appropriate, implement temporary moratoriums on licensing. And also subjecting providers who present identified risk factors to prepayment review. So Governor Walz announced that this is what we're going to be moving. And then on October 29th, he added more details, ordered a third-party audit of billing for 14 identified high-risk Medicaid services. And the identified services included HSS, the Autism Program, and ICS. But they also included all the other things that I've listed on that slide. There's a lot of programs that provide support for people with disabilities who are subject to this review. How was this implemented then, this governor's order? On December 1st, DHS announced a 2-year moratorium on new licenses for any service providers under any of its waiver programs, effective 2026, and it also prevents existing licensed providers from adding new services. And it's kind of hard to keep up with what else is going on because there's another moratorium that goes into effect, that went into effect February 26th, the 2-year licensing moratorium for adult day service providers. And that's all on top of moratoriums that have been placed over the past couple of years on other things, like group homes or nursing homes. There have been all these moratoriums in the past couple of years, starting in 2021 with the group home moratorium, that have really just plugged the pipeline for people to provide services for people with disabilities. The other implementation area was implementing those prepayment authorizations that Optum was looking at. They, on December 30th, suspended all payments to those programs without any notice. They just stopped paying them. And that's the story that we're going to be exploring now with the rest of our speakers. They're going to explore the consequences of those actions. The federal government's actions, Metro Surge, obviously had horrific consequences for the whole state. The other one about the $2 billion withholding, that hasn't happened yet. They have not withheld, the federal government has not withheld any funding from the state of Minnesota. That's just out there. But these other things that we described up from the state, they're in place. They have happened, and we're going to hear about the consequences of that. Our next two speakers are going to be Sue Schettle, who's going to provide, she's the director of the chief officer of the Association of Residential Resources in Minnesota. So she has the perspective of the service providers in Minnesota. And then we're going to hear from Sumukha Terakanambi, who is a disability policy consultant, who will talk about some of the effects on people with disabilities of these actions. So we'll start with Sue.
Hey, everybody. As she said, my name is Sue Schettle. I'm the CEO of the Association of Residential Resources in Minnesota, otherwise known as ARM. We are a trade association, so we do all the things that you think a trade association would do for residential providers. We provide education, we work on legislation, policy reform, networking, and all the other things that you would think that a trade association would do. So we've been around for about 55 years, and our mission is to advocate for, inform, and support Minnesota organizations serving people in the disability and mental health communities. So our membership, just to give you a snapshot of that, again, we have about 200 organizational members, and about 50% of them are for-profit and 50% are nonprofit. Our members range from really, really small organizations that might operate one community residential setting to like very large organizations. So we really do represent the providers that in this space from small to very large. I feel like I should move this back a little bit. So most of our members operate community residential settings, which are traditionally known as group homes, 4-bed group homes. They're licensed by the Department of Human Services. The license holder does not live in the home, so they have staff come into the home to support the individual based on what their needs are. And they rely on that model to advance the needs of the individual that's living within that home through an annual plan. The types of services that are offered in a community residential setting was touched on a little bit, but I'll just go through it quickly. Activities of daily living, someone needs support for showering, going to the bathroom, eating, communication skills, community integration, getting out and about and getting out of the house. They need staff to support an individual to do that. And then also medication oversight, hospital visits, that kind of thing. So it really does help the individual based on what their needs might be. And we also have a lot of members that do unit-based services. So those are services that are actually compartmentalized. And so they are services that you can bill for 15-minute increments and more than that. So we have members that do both. So I want to talk a little bit about the challenges that our members have faced as providers before all the fraud allegations have happened. I've been at ARM for 8 years, and when I walked in the door, the workforce challenges were very present, and they're still there today, and they were there well before I arrived at ARM. We have severe workforce shortages in the sector. It's a chronic problem. a very high turnover rate. We do an annual survey every year, and last year the turnover rate was the highest that we've seen in the industry. It's at 51.5% turnover rate within a year, but 50% of that number leave within 6 months. So you can imagine the churn that's happening within a provider agency of having to train people, they leave, train the next set of people, they leave. So it's a constant churn of people coming and going. The reason, I mean, there are a number of reasons why. It's physically demanding. It's a position that, you know, really does take a toll on an individual. Limited professional growth, unfortunately, for that sector. The options to move up and outside of direct support professional work is challenging. And there's burnout at all levels, from the direct care staff all the way up to the supervisory level. There's also low reimbursement rates. It's under $20, more like $18 an hour. They pay an individual to support a person's needs. It's not enough. It's money that is allocated by the legislature. So in order for us to get that up to 20 whatever the number is, we have to get the approval from the legislature. And that's been a challenge. Probably it'll be a challenge forever. There just never is enough money to support that work. There's a lot of unfunded mandates within the sector. Providers, especially nonprofits, have to raise money separately to support things that aren't funded through the waiver program. So that's a challenge. We have complex billing systems that are very antiquated, older programs that providers are asked to use and to utilize. I think that's been called out before in maybe some of the reports that the legislative auditor has highlighted. It's just sort of an old, clunky system. And there's backlogs and delays and just a number of things. I'm focusing on the barriers here, so it's not all gloom and doom, but I just wanted to highlight that. So some of the things that I was going to talk about here were talked about previously, so I'm not going to go into it too much, other than to say when the fraud issues began to come to light, the number of media inquiries were just crazy. I mean, I had more on that issue than we've had anything at all at ARM over the last, my 8 years here. So there's definitely a lot of attention to it. I'm sure you all saw the reporters, following providers coming out of their offices and, getting them on record about, fraud allegations. And again, Governor Walz issued the executive order for the 14 services that affected my members as well. And what they're doing now with that is they are doing revalidation. So they're going out to the sites, the 5,800 sites that are within the 14 services, and they're doing revalidation. So they're going out and making sure that they are legitimate, that there is an office and there are people that are actually working in these facilities. I think that's good. Maybe things like that should have been done routinely in the past. But we know that that's being stood up right now. The other thing I'll focus on a little bit is there's been a consistent challenge with communication with the department and the governor's office, especially as we look at the rollout of the 14 services. We were not informed, which was unusual. We were not informed of this big, huge change. We found out about it, meaning the trade association, found out about it at the same time the general public found out about it. And the communication that came out from the governor's office at that point was misleading. There was not great information. The providers were left with trying to figure out if they were going to get paid. Because that was not clear. And then once we got the information that came out from the governor's office, we pulled a meeting together with the department, and were assured that the providers would get paid when they submitted their claims. But the clean claims would get paid, and those that would get flagged would be moved over here and not get paid. And so we communicated that out to our membership, and we found out shortly as the program was unfolding that was not the case. So providers were left with really not having a whole lot of heads up that they needed to, get a cash flow, go to the bank to get a line of credit, to help support the work that they need to do. So that was handled really poorly, unfortunately. But we're looking toward the future now. So how are providers handling all of this? I think that many providers are looking at this as though they're demonized in the media as being a Medicaid provider. The narrative that's playing out is very negative at the moment. They're concerned about their future in this sector and how they're going to continue to work when the funding is questionable. They're certainly worried about the people that they support. They're certainly worried about how this will impact their ability to actually deliver the services for the people that need them the most. I hear that a lot from our members about, we can't float this work. We can't not get paid for the services that we are offering to people. We need that continuity, and that money is important. We can't just, continue to do that. So we've had providers had to lay off staff. They've had to really focus on what money that they can reallocate. We've had providers decide that they needed to take out a line of credit. So the prepayment review process was not rolled out very well, I will say. But I think that we are, providers are, we're back on track meeting with the department, and we are making progress in that regard. So that's good. So in summary, the disability service providers in Minnesota, as I said, the pay is an issue. The pressures are great. But despite all the problems that I've highlighted, I just want to leave you with my perception of the provider community in Minnesota. They're incredibly resilient and creative in how they manage the problems that are faced with them every day. They're in this work not to commit fraud. Many of these people that are leading organizations came up through the ranks. They were a direct support professional, then a supervisor, and now they're leading the organization. So they're in this work to care for people. I think everybody the providers that I know and that are members of my organization want to root out fraud just as much as everybody else, because this has been such a disruption of service and definitely a problem for the people that they're supporting. And as you know, they take care of the most vulnerable among us. They deserve respect, I think, and they should be allowed to do their good work while investigations continue. What some of our providers are experiencing is that payment stops, something was flagged, they don't know why, they're not able to go in and have a conversation about what information can I give you, or the conversations are not happening timely. So I think that's a huge problem in the provider community as well. And providers are a safety net for the people that need their support. So I think we have to get this figured out. I think we could do better as a state. And I know it was bumpy probably in, I would say, December, January, into early February. The communication was not great, but I think we're getting there. ARM has a meeting with the Medicaid director every 2 weeks and the DHS senior team. So I feel like that communication is opening up. But so if you have any questions, I think we're going to have options for that at the end. So thank you.
Okay, hi everyone. My name is Sumukha Terakanambi, and I am a public policy consultant. So I primarily work with the Minnesota Council on Disability and the Rare Disease Advisory Council. I'm also here today to speak and provide my perspectives and experiences as a self-advocate who relies on Medicaid services. I first wanted to start by thanking the organizers and the University of St. Thomas Law School for putting on today's event. This is actually my second time speaking at a continuing legal education seminar, so I'm excited to be back and talking with all of you today. So I first want to start by raising the question, why is today's discussion so important? So as someone with a disability, I think what has been happening has had a lot of impacts on, direct impacts on people with disabilities. Yet people with disabilities have not been adequately centered in this conversation. So today I'm happy for the opportunity to speak as a member of the disability community to talk about why these services are so important and really underscore that disruptions should not be happening. And I'll get to that shortly. But as I mentioned, I'm on a Medicaid waiver myself. So just to give an idea of what services Medicaid waivers provide, for me, I get PCA support through the waiver. I get transportation, assistive technology, medical equipment, transportation, and a whole lot of services that basically ensure that I can be as independent as possible and also live in the community. And so because of the waiver, for example, I was able to pursue higher education. I'm gainfully employed. I'm able to come to events like this. Really, it enables me to live the life that I want. And that goes for a lot of people with disabilities who rely on these programs and services. It's really about, like was mentioned early on, this is the way that the promise of the ADA and the requirements for integration, how that's fulfilled. It's through Medicaid services. So when disruptions happen, it's not just a minor inconvenience for people with disabilities. Oftentimes it's a matter of life or death. It could mean someone who is employed and contributing to the community, paying taxes. It could mean that they're losing their job and having to rely on family or friends. It could be someone having to move into a hospital temporarily because there's no services. Just in my example, without PCA support, I can't even get out of bed by myself independently. And I can only imagine if someone, fortunately, I live with my parents right now, so my situation is a bit different, but there are a lot of people who have external PCAs coming to their home to provide services. And if that's not happening, it can be a very frankly frightening situation for people with disabilities. So that's just to say, this conversation, I just wanted to mention all of that because I think it really sets up the experiences that I'm going to share with everyone. Basically to underscore, disruptions cannot happen. And so I experienced this issue both as someone who is involved in public policy, but also someone who, like I mentioned, is a self-advocate, someone who benefits from these services and cares deeply about these services continuing for people. I think everyone agrees that fraud is harmful. That was kind of underscored in a previous presentation from the OLA, that it undermines public trust. It hurts people with disabilities who should be getting the services and the funding. So I think that going after fraud is a very noble cause. However, it needs to be a balanced approach. Going after fraud should not mean that there's major disruptions in people's care. Continuity of care, to use a phrase, must be front and center. It must be part of any implementation from the beginning. It can't be something that is overlooked. And unfortunately, I think it was overlooked in this situation. I'm not entirely sure if I'm hoping things have moved in a better direction, but yeah, definitely it was not part of the equation when some of this stuff was being rolled out. So just personal, I think this was already mentioned but just the mixed messaging with the prepayment rollout, even as someone who is involved in conversations with other policy professionals, even people who do this for a living, were in the dark, did not know what was going on. It wasn't very clear how things were messaged. And I think that caused a lot of fear and anxiety for people with disabilities and members of the disability community. So just to give an example, with the prepayment review program, initially there was a lot of fear in the community that there was just going to be a 90-day pause across the board for all the 14 high-risk services. So there was even a meeting with providers and advocates to figure out our response to what was happening. And then I actually, as part of my work, I'm on the Developmental Disabilities Council, and we had someone from the governor's office talk to us about sort of reassuring us how the prepayment review was supposed to happen. I think Sue already mentioned it, but basically any claims that were not flagged were supposed to be paid out as normal. So that's what we were told, and I remember coming out of that meeting thinking, oh, okay, maybe it's not going to be that bad. Maybe things will be fine. And then in December, late December, January, that's when things kind of seemed to fall apart pretty quickly. The communication broke down almost from the beginning, and that's not what happened. In fact, payments were held for several weeks, and it was causing uncertainty for providers. And then, of course, that trickles down to the staff and then the people who receive the services. And so I will tell you, like, this was an issue, I was working on at MCD, kind of tracking what was happening. And just as I was doing my work, I was personally, even though I didn't face any disruptions in services, I was extremely concerned that the disability services system was collapsing because we were hearing things through work and both, mainly through work, but that people were losing services, people were having to move into hospitals, people were homeless. There's even few people who have died because of what has been happening. So all of that was kind of swirling around. At MCD, we had a Let's Talk About Disability Services town hall to really hear from the community, because we were hearing from both providers and constituents who were rightly very concerned about what was happening and felt that there was no collaboration from DHS to address some of this issue. And there was a self-advocate, another self-advocate who was gracious enough to share her experiences at her at MCD's town hall, who said something to the effect of, "We can't keep justifying our existence." And I thought that was a very powerful quote, because I think that highlights what encapsulates what people with disabilities were feeling at the moment, because we have to keep, it almost seems like we have to keep having this conversation about making sure people with disabilities and those who directly benefit from the services are front and center, and that our needs are being addressed. And to justify these programs, right? Sometimes with the allegations of fraud, some people have made statements like, if there's so much fraud, why are we funding this? There was always people who were wondering why we were funding these services for people with disabilities. And I think that has sort of been made worse with all the fraud stuff. So yeah, that it just feels like a constant fight, and I think that was well said by that other advocate at our town hall. So what should be done going forward? I personally believe a lot of these issues could have been resolved from the beginning had there been better communication and collaboration. While I agree with the DHS and governor's office focusing rightly on fraud prevention, they very much lost sight of how people with disabilities would be impacted. They really did not prioritize continuity of care. And I think that's clear by some of the stories we were hearing and some of the concerns that people were facing. They didn't really consider how pausing payments could then trickle down directly to the service recipients and mean that they could lose their staff or have direct impacts. And so going forward, I think more collaboration with the disability community is extremely important. We need to hear more from people who are most impacted, because they can provide that perspective about what these disruptions really mean and how to avoid it. So I think that's really what one takeaway would be is just more collaboration with the disability community. We have organizations that have expertise like MCD, ARC Minnesota, the Developmental Disabilities Council, who we have an understanding of the system and how to make sure it's more equitable. So if there's one takeaway, I think continuity of care is extremely important and always has to be front and center when these kinds of policies are being implemented. I think that's it for me. Thank you so much again for the opportunity, and thank you all for being here today.
Okay, at this time, we're going to all clear off of the stage, and the next group of speakers is going to come up and share some thoughts about where do we go from here. Moderating a conversation is going to be the Honorable Becky Thorson, and the two contributors to the conversation are Mr. Shamus Amira, who has litigated very significant cases for the rights of people with disability in the state, and joining us from remotely will be Dan Stewart from the Minnesota's Office of the Ombudsman for Mental Health and Developmental Disabilities. So I'll leave it to them.
All right, well, we will have a conversation up here. I hope I'm feeling so educated about so much that I didn't know, and I'm so pleased to bring a couple of incredible advocates to the stage here. And Dan Stewart, I see you on the video there. Can you see us?
I can. Thank you, Judge.
Great. Well, Dan Stewart has just been introduced, and he is appearing by video. And we've got Shamus O'Meara on the stage, and Shamus and Dan will have a conversation. I'm here to facilitate. I think Dan and Shamus may do some conversation on their own, and we're going to begin by hearing a little bit from both Dan and Shamus about their experience as lawyers and advocates in promoting disability justice in our community and around the country. And so I'll start with you, Dan. And your role, of course, today is different from your role that is set forth in the bio summaries that people have in paper on the tables. But can you describe your role today as compared to when you were director of the Disability Law Center?
Yes, thanks, Judge. I really appreciate the opportunity to be here as a part of this great presentation. I too have learned a lot, and especially pleased to be here as a part of this panel with Shamus O'Meara. I'm honored to be here and part of the constant fight, as was just described, as well as to have had the good fortune of being part of a network of safeguards, of watchdogs, and fundamentally just good people that have dedicated themselves to advocating and supporting people with disabilities. Both the Disability Law Center, or DLC, and the Ombudsman's Office have unique roles. For example, DLC, which is part of Mid-Minnesota Legal Aid, which has a long history on serving people with disabilities, going back to the Welsh lawsuit in the 70s. And the Disability Law Center serves, of course, as the state's protection and advocacy system, which is part of a network of national providers and service safeguards of people with disabilities. The Disability Law Center has monitoring authority to conduct announced and unannounced visits, and does have advocates, attorneys, and law students to provide free legal civil services to people with disabilities. And I'll just contrast that with my current role at the Ombudsman for Mental Health and Developmental Disabilities, which, like the OLA, is an independent state agency, but our office is charged with the task of promoting the highest attainable standards with respect to treatment, competence, efficiency, and justice. It has unique statutory obligations and authority to obtain data, conduct neutral investigations, and conduct unannounced and announced site visits at our discretion. We also review serious injury and death reports, among other functions. While OMHDD is not a regulatory body or a licensor, we can weigh in on issues of statewide significance at the legislature and policy levels, and we have done that as recently as earlier this week before the State Senate Committee on Human Services. Minnesota is fortunate to have both the Disability Law Center and OMHDD in this network, in addition to the Governor's Council on Developmental Disabilities. That's where Dr. Colleen Wick is the executive director. The University Center for Excellence on Developmental Disabilities, and that's called here the Institute on Community Integration at the University of Minnesota. And of course, the private bar, including my esteemed co-panelist, Shamus O'Meara, and I think, Judge Thorson, you have a question for him.
Thank you, Dan. And for the audience, if you wonder where I'm looking when you see Dan behind me, I've got a monitor up here. So I just thought I'd let you know why I have my back to Dan sometimes. Well, Shamus, thank you for being here, Shamus. And you have been handling some of the federal court cases that are featured in the banners. We're here in this session to talk about where we go from here and what your perspectives are, but it would be helpful for you to share your experience as an advocate before we begin to dig in.
Sure. Well, thanks everyone for being here. It's important, I think, for those of us who aren't advocating every day and maybe just are pausing to hear about this to understand how important these issues are. So thank you for being here. So, Judge, to me, advocacy is a lived experience. First and foremost, as a father of a young man with autism, our family advocates for him, and he advocates for himself as a self-advocate. To people with disabilities throughout Minnesota and throughout this country who advocate for themselves, for their families, for the good work that advocate organizations do. Together, we are strong and we have a voice, and maybe part of the banner that you're asking us to reflect on is that together we are strong. And we need our strength, especially for what's happening to people with disabilities now. It's appalling. The hard work that's been done, and all you have to do is look at these banners and read them, and I encourage people to do that. Throughout 150 years of advocacy, to get here and closer to where we need to be, and then to have what is happening in real time in Minnesota to our vulnerable population by the state of Minnesota, without thinking, without notice, without any contemplation, and just cutting off funding to providers who provide critical care for people with disabilities to live in the most integrated setting pursuant to their own choices and their own decisions, and to take that away without due process is appalling. And it needs to be addressed and named.
Thank you, Shamus. And that's what we're here to talk about in this session is what do we do about it? And I can't think of a better way to have set this up than to hear from Sumukha. My goodness. What a way for us to really understand in ways that we aren't, hearing about in the newspapers. Of course, we all want to prevent and address fraud. But what we are hearing today, and we're hearing it from people with disabilities, about how it is affecting services and rights. And so I want to talk about the rights. We hear about due process. Of course, those who are accused of fraud, they have due process. We hear about that. The providers, I know there's some litigation, there's due process. But let's talk about the legal rights of people with disabilities as we think about the wrong that we're talking about here today. And Dan, I'll turn it over to you, and then we'll hear more from Shamus. So, Dan?
Yes, thank you, Judge, and thanks, Shamus. One thing that I've been thinking about is how the rights of people with disabilities are really impacted by what's happening now with actual fraud and allegations of fraud. And I think there's a severe and negative impact, and I'll talk about that a little bit more. But I want to expand on the historical framing. So you've seen the banners around you in the lovely atrium there, and you'll see the long history of people with disabilities suffering rights violations and threats to health and safety. We've seen the horrors of institutionalization, and that was partially but fundamentally addressed in the 1970 Welsh decision. There's been the rampant and illegal use of restraints, and that's the Jensen case, of course, and Shamus may talk about that more. The denials of services to people eligible for the waiver, and that's the Guggenberger decision. I'm sure Shamus will talk about that as well. And then we also have denials of informing people with disabilities of options, simply options, for integrated housing, and that's the Murphy decision. Now we have the effort on fraud mitigation, which I think is the latest version that victimizes people with disabilities. And I'll encourage and let the audience speculate on how the fraud triangle that Judy Randall just talked about and which components are most impactful here when we're talking about people with disabilities, but I think a lot of it is the motivation side. But when we're talking about the actual impact, we've heard the prior speaker, but I also want to report on some issues that our office has seen, and that is fraud and related reports involving ICS, or the integrated community settings, which was also previously mentioned. Fundamental concerns about services just simply not being provided to people with disabilities. Services suspended, in payment issues in residential and non-residential settings. We've seen housing loss due to fraud and fraud mitigation efforts. We've also seen death reports involving concerns attributable to services not being provided. And there are examples in the media that I'm sure that you're aware of. And we do have that overall risk, or the pall, I would speak of, this hanging over service provision. People with disabilities may not know if they're going to get services tomorrow or the next day, services that people depend on for their health and safety, but also the community integration. So that's my response to that. I think it's a huge and important topic, and I'm just so grateful that we're discussing it today. And back to you, Judge.
Thank you, Dan. And Shamus, in continuing the conversation here, I'd like to hear from you as an advocate who's in court about your views of the legal rights that are being violated. And does this situation remind you of any past case, and is history repeating itself?
Yes, it does. I'm going to read you something from CMS, the Center for Medicaid Services. It's their Medicaid Payment Suspension Toolkit that they publish and that they put out to all the state Medicaid agencies. That's the Minnesota Department of Human Services. And this is important. In making any decision relating to the payment suspensions, the state Medicaid agency has an ongoing responsibility to ensure that beneficiaries, that's people with disabilities, have access to appropriate critical services and must balance ease of access to care against potential risks raised by credible allegations of fraud that triggered the suspension. In my view, none of what the state of Minnesota has done is about balance. They decided that everyone is fraudulent or suspects that someone is fraudulent, and without notice, they stop payment. And people are dying, and our expectation is more people may die. I read a stat, I think it was some testimony before one of the legislative committees this past week, that 255 individuals with disabilities have been evicted from their home setting. People are homeless. Think about that. Vulnerable citizens in this state have been evicted from their living situation because the provider hasn't been paid, they didn't get notice, they're under some prepayment plan, which, by the way, the legislature passed a law that went into effect in 2025 that says you can only suspend payment for 60 days. That's being ignored. People that we love, that we need to support, are tossed aside and evicted and are dying, and that is wrong. So with that predicate, I'm reminded of a class action lawsuit that Dan, you were part of with the Disability Law Center. In my office, we were co-counsel. We sued the state for failing to spend $1.1 billion that they didn't spend over 20 years for people with disabilities who they stuck on waiver waiting lists. The waiver that Professor Schiltz talked about a few minutes ago is the golden ticket. It's your access to monies and services to live in the most integrated setting. Maybe with a sibling, maybe in an apartment, maybe you can have mom and dad over for coffee. These are choices that people want to make. And because they happen to have a disability, they need to be supported. And despite all of the law and the Supreme Court case in Olmstead in 1999 requiring that state agencies support people in the most integrated setting, the state held on to $1.1 billion. They didn't pay that out. They just kept it. And we had clients that were on the waiting list for those services for up to 14 years, maybe more. And that was completely wrong. And so we had to sue them in a class action lawsuit, and it resolved itself. The waiting list suddenly disappeared. People got their services. Well, that was because of the advocacy that we had to bring in federal court. Fast forward to here, it's the same thing. The state of Minnesota is not out one dime right now. The Center for Medicaid Services, the federal component that handles Medicaid monies, has threatened to withhold $515 million per quarter for 2 years. The state of Minnesota, while not being out any money, has decided to cut off payments to providers and thereby putting people with disabilities in severe jeopardy, being evicted, and we're hearing about deaths now. So if you think about that, there are all sorts of different things that are impacted, and first and foremost, it's the civil rights of people with disabilities. Under the integration mandate of Americans with Disabilities Act, the Social Security Act, the Medicaid statutes, the Jensen case, the Guggenberger case, where we brought the waiting list, the Murphy case that Dan's office brought with class action lawsuit against the state to support their individuals with disabilities in choices in the most integrated setting, apart from group homes. And so people with disabilities don't have money now, and where are they going to go? Once they're evicted, maybe they'll live with their family, but maybe they have critical needs, Judge, that can't be supported in the family home. They're going to go to a hospital or a nursing home situation, and if that's where we're going to be, you might as well take a torch to all of these banners and go all the way back to the banner where people were living in institutions, because that's where we're going. And I'm not overstating this. I mean, talk to the families, talk to the self-advocates that are out there. We had a wonderful self-advocate just a moment ago speaking about his experience and what he heard. We're getting phone calls and emails by the dozens every single day. And when you go over to the Minnesota Department of Human Service, or Minnesota Legislature and the Human Services Committee, and you hear all of the stories that are being presented to, John Hoffman, the chair, Jim Abler, Republicans, Democrats alike, in a bipartisan voice are saying, what the hell is going on? What's happening to people? Why didn't you come to us? Why didn't you notify us? This is wrong. You are responsible for the continuity of care, and it's not happening.
Now, Dan, reflecting back on your work at the Disability Law Center, and you were involved in the Guggenberger case, do you have anything to add about the way you look at Guggenberger? Well, you looked at it then and look at it now?
Yes, thanks, Judge. And I fully agree with Shamus in terms of the analysis, but also that we're here again. And I'd like to also emphasize that time and time again, we are in the situation where there are rights for people with disabilities without remedies, or at least many rights without remedies. Now, Shamus talked about the ADA, the Olmstead decision. I'd also add Section 504, state and federal constitutional issues, as well as the Minnesota Human Rights Act. And I just want to point out, in terms of a legal lay of the land, those are of a different nature than more directive laws that list out eligibility, steps that providers need to follow, service provision, mandates to provide services. And that's a lot of the waiver programs that we're talking about, and to some extent, services for other people with disabilities. In this latter group, the eligibility step, service provision, the fundamental question is what happens with respect to rights when services to people with disabilities stop due to fraud mitigation efforts such as what we're seeing right now, fraud itself, or as the prior speaker said, staffing shortage? The answer is not much. And that is so important, because if you have these rights and very limited effective remedies, then what happens to people with disabilities? They're left in the streets. They're left without services, and they're severely neglected, and they're subject to abuse. So that's why you see Disability Law Center, Shamus O'Meara, the Ombudsman's Office, Governor's Council on Developmental Disabilities really look at different advocacy strategies. And then the lawyers in the room can resort to the ADA, constitutional claims, etc., the due process rights that you'll see on the banners. But that's a really hard pathway, and it's not a quick pathway, especially for people with disabilities who lack in resources or connections. And so when we're talking about if we're back to Guggenberger, yes, of course we are. But I would also say that we're back, as Shamus just mentioned, we're back fundamentally to institutionalization. And that's where we're headed, and that's got to stop.
Well, we are not going to burn these banners, right? So what we're going to talk about in our last question, again, this exhibit was prepared about a year ago with an amazing team, and this was labeled the unfinished journey. We are going to continue progress. So the last question to each of you is, look at that blank slate. There's another banner to be made. I'd like each of you, and I'd love all of you, to think about what would you like that banner to say? What did we do? What should we do? And so I will begin with Dan and then end with Shamus. Dan?
Thank you, Judge. One thing that I'm thinking about is, most of you have heard about the effort of treat people like people. So one optimistic view is that we treated people like people. We know that there's a spectrum of disabilities. There's a spectrum within each disability. There's a spectrum within each person. And I'll suggest that once we really look at these spectrums and how they apply to each of us, including that person in the mirror, you'll see more similarities than differences. And if we're starting there and treating people like people, then I think we'll have more recourse to having effective remedies, but also preventing the problem in the first place, because these are people that we care about. Could be ourselves. It could be our parents. It could be our cousins. It could be our kids. It could be our friends. So if we treat people like people as we should, we'll have that common core of dignity and respect and treating people like value. Turn it over to Shamus.
Shamus, your closing statement. I expect the trial lawyer in you will come out.
You don't think it has yet? Wow, that's a good one. Dan, you knocked it out of the park. These are good people. These are our loved ones. These are neighbors. They're parents. I don't know why we're here doing this again, but that banner should be your mirror, and everybody can walk up there and look at themselves and ask what they've done to advocate for their brother, for their sister, for their loved one, for each other, for themselves.
Thank you, Dan, and thank you, Shamus. And I can't end without saying something about somebody who's not here today, but usually is here when we have a disability justice program, and that is Judge Donovan Frank. And I know I see some heads nodding. Judge Donovan Frank is depicted there, and so he has been very busy these days, and we understand that he couldn't make it today, but I did want to express my own gratitude for all that Judge Donovan Frank has done in helping to lead and help with these seminars. And with that, I'll turn it back to our fearless leader, Professor Schiltz. Thank you, everyone, and thank you, Shamus and Dan.
According to my watch, we have about 10 minutes for questions. So if anybody in the audience has a question for any of the panelists, maybe we can answer the questions. Either everybody can go back up there, or we can answer the questions from the tables where we're sitting. And if you just raise your hand, I'll bring the microphone to you. No, but we're recording this.
Oh, okay. So I had a question for Shamus. If I heard you right, you mentioned that you were reminded of a class action lawsuit, and I'm just wondering, is that an option?
Is a class action lawsuit an option? It always is. It should be a last resort. There should be dialogue. And what we've done in the past is we provided an opportunity for the state or whomever we're about to sue to have that dialogue with us. And the first order of business is to talk to our clients. It takes a lot of courage, as Colleen and Mary Jo from the Governor's Council on Developmental Disabilities know firsthand, for a family to be a named plaintiff in a class action lawsuit, right? Because you become a target. Your deposition might be taken, all right? You are out there, right? And so that's the first order of business. And then it's a matter of notice to the state, probably to the Department of Justice Civil Rights Division, so that they know what's about to happen. And you want to give the state an opportunity to change its conduct. Because once you start down that road, it's tough. In the Jensen class action lawsuit, we sued it out, Dale, in 2011? Sounds right. We settled it. 10 years later, we had an Olmstead plan. Am I right? 2020. 10 years. Okay? Guggenberger, which turns into the Mickelson case because they gave our clients the waivers, took how long, Dan, if you're still on? He's not anymore. Maybe 5 years. The Murphy
That's
case.
about 5 years.
Housing case, independent choices, another 4 or 5 years. It's an option. It's sort of the last resort. But people are really hurting. And this might be a situation where we ask for a temporary restraining order to stop this conduct because it doesn't match anything that the CMS guidance has provided to the state agency, the Department of Human Services. It seems to be done without any discussion with any of the provider network, any of the advocates, any of the families, and I'm with you. Maybe that's a step, but it's got to be vetted a bit.
I have a question for the lawyers. What are we doing in the state of Minnesota to ensure due process rights for the disabled waiver recipients? Because what we have is a situation right now where DHS is not recognizing due process rights of waiver recipients unless the agency issues a notice of action, which limits and gatekeeps the issues that can be brought forward under the statutory laws for jurisdiction. And I will volunteer to be the named person in your class action if you will bring one.
Are you asking me what I believe the state is doing to ensure due process for vulnerable adults in this setting? Nothing. In general? I'm not plugged in there. That's probably a better question for Dan Stewart, who has conveniently left the seminar. He's back. Right on cue. Did you hear the question?
Yes, it's a complicated question. I heard it, and I think one fundamental thing is to continue relying on resources to get DHS to issue those notices, so then you'll have due process rights that attach to them. However, of course, sometimes that doesn't happen, and there are some legal tools available, including potentially mandamus actions or others. But I think most of these are going to be problematic from a class action perspective due to the individualized nature of the situation. But if there's some way to find patterns and practices, then we're in a different category.
Another question here?
Yeah, I think my question, Rebecca Dosh speaking here, for Judy Randall. You talked about just the basics of walking around the barn and knowing what's going on, making sure the basic regulatory structure is in place, and that is the state's responsibility. My question is about funding for that regulation and the regulators. Is that lacking, or was it simply a lack of oversight of the required oversight? Thanks.
Thanks for the question. I think it depends who you talk with on the answer you'll get. I don't think it's a matter of lack of funding for the state agencies to be doing that. I think it's a fundamental responsibility of what the agencies should be doing. Now, that being said, there are ways to do it that are focused on risk so that you don't take, so that, for example, let's say we expect them to go monitoring, right? Go show up, see if the services are being provided, right? I think an agency could fairly say, we don't have the staff to do that for all 5,800 providers, or, pick your number. And that's fair. And I don't think as a state we want to put that much money towards that, right? But I think you could say, okay, fine, right? Let's develop a process to identify providers that are highest risk. Let's look at the data we have. Let's look at new providers or providers that grow suddenly, or, pick your metrics. There's lots of them. And let's prioritize going on site to those, right? So you don't have to go visit every provider every year. Maybe you hit every provider once every 5 years, but then you're doing more frequent of those who raise some red flags, right? And you might find everything's fine. You might find that they need some technical assistance, or you might find that there are some serious problems. So I don't think it's a funding issue. I think it's a priority setting issue.
We have time for one more question.
Thanks. My name's Sam Orbovich. I used to represent providers for about 40 years in this state, and then I retired a year and a half ago just before all this happened. I have a question for Ms. Randall first. I was reading the report that came out by Judge O'Malley this morning to prepare for today's session, and there was this appendix that has Office of Legislative Auditor reports and summaries going back almost 50 years. But isn't it true, since we're in a law school, that the definition of fraud is an intentional criminal act where somebody is trying to get a financial benefit for themselves or somebody else? If you look through your reports over the last 50 years, how many of them actually focused and found fraud as compared to irregularities of contract payments, irregularities or debates about how rules are supposed to be spent, or just plain that the agency was allowing something to happen that wasn't fraud, and maybe it shouldn't have necessarily resulted in an overpayment, but what we have here today is the simple fact that the allegation of fraud is a nomination a provider wins simply, it's an election a provider wins simply by being nominated. And it seems to me that with the presentation today, if my count was right, in this world, not feeding our futures, but there have been 10 or 11 cases, criminal cases brought against providers. You just mentioned 5,800, however many providers we have in this state. Isn't it true that it's more important and that people should be focusing, at least when they're construing your reports over the years, separating out between something that is actually fraud, an intentional act, and something that is a mere overpayment?
Thank you. Great question. And I have the O'Malley report with me, actually, and have read it and will continue to read it. So first of all, absolutely. Fraud is something that is frankly determined by a court, right? So people are using that term pretty loosely. I think it's better to say alleged fraud until it has gone through the whole process. So yes, fraud requires intent, a demonstration of intent, and has to be determined by a court. If you were here when I was talking about the fraud triangle, our reports are focused on that opportunity piece. Our reports, it is very unusual for an audit to find fraud. It's not what an audit is supposed to do, honestly. The best way to find fraud is through tips. That's how most fraud is identified, is through a tip, a whistleblower allegation, something like that. It's usually not found through an audit. What an audit does is help to strengthen those internal controls, that opportunity. And that's what we're focused on. And so this roadmap that came out from Judge O'Malley is, roadmap to program integrity and fraud prevention. It's all about closing those opportunities. So no, most of our reports, I certainly hope none of our reports say we found fraud. We sometimes say we found indicators of fraud, right? And we would pass those situations on to the Bureau of Criminal Apprehension or the FBI or others to investigate and enforce. But things that start as these small vulnerabilities, these maybe an overpayment, maybe an honest mistake, those are kind of the gateway. And so when I talk more about this, I talk about how fraudsters they test out the system and they're looking for those opportunities. So first, I don't know if you can, they might just try and move the water bottle a little. Oh, nobody noticed. Oh, I'll move it more. Oh, I'm going to take the water bottle, and still nobody noticed. And so our reports are focused on catching the little movement of the water bottle, not fraud, not anything big yet, before somebody is actually stealing, letting the horse out of the barn, et cetera. So I guess I don't know if I answered your question, but I would say yes, we didn't identify fraud. What we did is identify ways for state agencies to, fix the door, tighten the window, use your metaphor, so that then there's not that opportunity for fraudulent behavior.
Thank you. I'm going to be closing the program up formally now. Before I do that, one housekeeping matter, if you're here, for CLE credits. The sign-in sheet is on that table in the back corner, and we've applied for 2 hours of elimination of bias credit. It hasn't been approved yet, it's still pending, but the number is, for this event, is 544-505. So before I invite everyone here to come back to the bar and to the reception table and have some food and continue the conversation on a one-on-one basis, I just want to thank, first of all of our contributors today, Sumukha, Sue, Shamus, Becky, and Judy, and Dan, who's gone. So thank you. And I want to thank all of you for caring enough about this issue to show up. I want to urge you to help listen to Shamus's call and help be part of the group of advocates that ends up writing another banner that says, we had this crisis in Minnesota and we came up with a solution. We listened to the people who were affected by it, and politicians and lawmakers got together and crafted a solution to the problem that addressed the fraud and did not take away services for the people with disabilities. So next time we have a program like this and we bring the exhibit out, I want all of you to have been part of writing the text for the next banner in the exhibit. Thank you very much.